Thank you all for coming out, and welcome to our debate on the Patriot Act. My name is Leanne Ford. I'm the Federalist Society Chapter President for the Grand Rapids campus of Thomas M. Cooley Law School, and I welcome you here today as we debate the Patriot Act. I also want to say welcome to Grand Rapids Community College, who is taping the event. It will be ran on educational TV on cable, as well as video stream on the internet. And I'll post updates on the Twin page for those of you whom are students here at Cooley. You can access the Twin page at GR Federalist Society and look for that update for where this event is going to be ran at. I'd like to introduce the rest of the board members of the Grand Rapids Federalist Society. If you guys wouldn't mind standing, I know you're kind of scattered about, but Joanna Smith there in the middle is our social chair. Next to her is Tom Smith. He's the vice president. And then we have Mike Lichterman, who's the treasurer, and Bruce Merchant is our secretary who was unable to make it today. I want to say a few, just give a brief introduction on the Federalist Society, a brief overview. The Federalist Society for Law and Public Policy Studies is a tax-exempt 501c3 organization, educational organization, comprised of law students and lawyers interested in the current state of legal order. It is founded on the principle that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is the duty and providence of the judiciary to say what the law is, not what it should be. Our mission on this campus is to provide a forum for fair hearing on by legal scholars through such means as lectures, speeches, and panel discussions. Last term, for example, we hosted Federal District Court Judge Gordon Quist on this campus. He discussed the history of federalism. We also held mock oral arguments on whether or not the Federal Controlled Substance Act preempts Oregon's Assisted Suicide Act, which permitted assisted suicide through prescribed drugs.
Leanne, I might mention that I was part of that discussion, and my side won.
You beat me to it.
So,
yeah, you beat me to that.
I think largely because of my brilliant argument in front of the Federalist Society, the justices took note of that.
And since Mr. Andling isn't here to defend himself, I do encourage you to become involved with the GR Federalist Society chapter on this campus. Membership is only $5 per year. We have membership forms on the Twin page, which again is at GR Federalist Society. And I also have hard copies with me here today. Feel free to speak to any of the board members if you have any questions, want to learn more about the Federalist Society, or become a member. Now I would like to introduce our esteemed guests, one of which you've already heard from. Mr. Schindler is a partner at Warner Norcross and Judd. He is a graduate of U of M. He also clerked with the Ninth Circuit on intelligence security matters. He also has a radio show on WGVU. He specializes in, or he's a compliance attorney with a focus on healthcare and land use planning. He's a chair of the firm's health and law practice group. He is also a founder and former president of the Grand Rapids Federalist Society Lawyers Division. And as well, he served on law review with one of our deans here, Dean Miller. In today's debate on the Patriot Act, he will be arguing or opposing the Patriot Act. So thank you very much for being with us here today. And then now we have Mr. John Allen, who's a partner at Varnum, Rittering, Schmidt, and Hewlett. He is involved with litigation and trial services, corporate services. He served on the chair of the State Bar of Michigan Ethics Committee and Professional and Responsibilities Committee of the American Bar Association. He also served as captain of the Judge Advocate General Corps. He has over 30 years of experience. He has several family members, children, Margaret, who's a graduate of Northwestern and is now a practicing attorney in Dallas, Texas. Tom, who's a graduate of the University of Michigan and Michigan State University. And Anne, who is a senior at the University of Michigan. So thank you again for being here today. Just a quick rundown of itinerary. Mr. Allen has put together a historical synopsis of the Patriot Act. And, it's hard to put the act to cover everything in the act in a 45-minute time frame. So he has put together a synopsis to help put today's event into context. We're going to follow that with the debate between the two opposing parties here. I should mention that Mr. Allen will be arguing in favor of the Patriot Act and its extension. We're going to follow that up with a discussion, so we'll open it up to the floor for about 10 minutes' time, and if you have any questions, please keep those in mind, and you'll have opportunity to address the panel thereafter, and then we'll break for lunch. So we should be eating in the student lounge by 1 o'clock, hopefully. So, all right, thank you.
Thank you.
Mr. Allen?
I'm going to walk around here so I can punch buttons on this computer. Good afternoon to all of you, and thank you very much.
John, you have to use the microphone.
Dean Miller, thank you. Thanks to all the students who braved the cold weather today to come out and join us. The Patriot Act is, I believe, just a little bit over 200 pages in 12-point type. We aren't going to talk about all of it today, I warrant to you. This will be sort of a Reader's Digest large print version of some of the major issues that arise within it. I also apologize to you if you see me squinting a little bit. I'm on the short end of a little bit of eye surgery last week. I wish I had something romantic and daring like a hockey fight to relate to you, or that Deb and I got into it before the session today and had a spirited discussion, but that's not really true at all. It's just one of those things that happen when you put about 6 decades in on the planet. They find things that they need to do to you once in a while, so I apologize for that in advance. And we've started with not being able to go forward. Fascinating.
Try the forward key.
Try to click the mouse.
Haha, that worked. I didn't go quail hunting with the vice president either, but I thought I'd maybe start with that today. Introduce you with a scene from the White House Situation Room, a discussion between the Chief of Staff and the Chairman of the Joint Chiefs of Staff, a full admiral played by John Spencer and John Amos on a program that some of you may know. I call it Left Wing. So far, the technical stuff is doing well.
If you like, John, I could dub in voices.
Well, so much for that. Let me relate the discussion to you as best I can. I apologize for the technical deficiency. The Joint Chiefs is having a discussion with the Chief of Staff of the White House. They're contemplating the assassination of a fictional leader of another country who's involved in state-sponsored terrorism. And the Chairman of the Joint Chiefs is relating to the White House Chief of Staff that he doesn't really know when it's war or peace anymore. And he figures he's one of the best experts on the planet on that topic, and even he cannot tell anymore when it is war or peace. This will be very quick, a list of things that at the time weren't regarded as very important. They start about 40 years ago with the hijacking of U.S. aircrafts. They go on through the assassination of foreign leaders, the bombing of U.S. embassies, assassination of naval officers and CIA officers, the assassination of prime ministers of democracies. other hijackings of other airplanes, of cruise ships, of bombings of discotheques and party places where only civilians and not military gather. The bombing of the World Trade Center in 1993, something that I'll talk about just a little bit later with a special link to 9/11. Other assassinations. Timothy McVeigh comes back after visiting the Islamic area of the Philippines and bombs a building in Oklahoma City. The Khobar Towers bombing, the East Africa embassy bombings in 98, the Cole bombing. Osama bin Laden gives speeches in 98 and is quoted widely in the American media that they are targeting civilians as well as military, and that his followers consider it an individual duty to follow his fatwas or orders of warfare, and that they do not differentiate between military uniforms and civilians. All are targets, and that their hostility is towards America and toward all Americans. The news media in early 2001 says we should have little fear of this. They regard the bin Laden network as more analogous to the Elvis Presley fan club, and that counterterrorism should be regarded more like public health or highway safety. In 2001, in August, there are more anxious speeches given by the leaders of bin Laden's followers, and that they speak specifically about blowing up towers, objects of pride of American democracy and economy. There's a public trial of an al-Qaeda member in France about those East Africa bombings. During that trial, there's what we would call a probable cause hearing held on why certain investigation techniques were used, and in the course of that, it is revealed that French authorities were given information about a radio telephone used by bin Laden. The day of that hearing, Mr. bin Laden's radio telephone falls silent, and we don't hear about it again for a few months. Pictures are still hard to watch. Gary Trudeau assesses the situation of American ignorance and I think the temper of the country very well at that time with this cartoon. 2006, about a little bit over a month ago, Mr. bin Laden announces that the war against America is still on. It won't be confined to Iraq, that other events will occur in the heart of your land as soon as the planning is complete. Article 2 of the Constitution, for those that remember Con Law 1, talks about the powers of the president and gives him war powers. The Supremes have commented on this several times over our history. One common element we hear is, does a war require an act of Congress? It doesn't, of course. There is something called the War Powers, some people call it the Act. It's not the War Powers Act, it's the War Powers Resolution. It was never signed by the president because the president would have vetoed it. It's a resolution like Sweetest Day. And it says that the president's supposed to check in with the Congress when he sends troops overseas, although there's nothing in the Constitution about that. The Patriot Act is one tool of many that is used in this, most of which, and in fact many parts of the Patriot Act have really existed for a long time. It was more a refinement of existing tools than it was creating new ones. They include the Foreign Intelligence Surveillance Act, the FISA statute you've heard so much about recently in the newspapers. A plain old grand jury subpoena was used very often to gather information about intelligence and about even folks who were at war with the United States. Something called an NSA letter or a national security letter. You'll hear more about those today, I'm sure. And the Article 2 war power, which again, if you remember from Con Law 1 and Youngstown Sheet and Tube, the Supreme said there's three kinds of executive power, some which is derived directly from Article 2, some which is delegated to the executive branch by the Congress, and some which the President exercises despite the fact that the Congress legislatively tells him not to. And that all three of those may be valid exercises of an Article 2 power. The Congress has no more right to control the exercise of Article 2 powers than the President has to control the exercise of Article 1 powers by the Congress. There is an act of Congress which forms some of the basis and the prelude to the Patriot Act. That, of course, is the Senate Joint Resolution 23, passed 98-0 in the House, 420-1 in the House, 98-0 in the Senate, which was the statute enacted immediately after 9/11, which gives the President authority to use all necessary and appropriate force. I'm not going to get into this detail because we don't have time for it today, but I want to distinguish that in war we operate a little differently. We make much more use of military tribunals. We distinguish between prisoners of war and enemy combatants and aliens, and those different categories get different treatment. A POW is a particular type of creature under the Hague and Geneva Conventions. It is not merely someone who is a prisoner who is captured during war. It is a legal definition and a term of art. You must fulfill 4 different definitions. If you don't, then you're classified as a spy. And international law and the law of nations from time immemorial has permitted summary execution of spies. You have no rights under the Constitution or any of the international conventions. Enemy combatants are the same way in some respects as folks who do not qualify for prisoner of war status. They are people who take up arms, in our case, against the United States. The law of nations is that they may be detained for the duration of the hostilities so that they don't pick up their arms again and start shooting. How long is the duration? I call it the John Belushi principle. It's not over till we say it's over. Actually, it's the victor that gets to say when the hostilities are over, and hopefully we'll be the ones that have that prerogative at the end. At any rate, enemy combatants are not POWs, and they aren't treated the same way, and our law does not require that. And they are also not entitled to United States rights. Typically, the Constitution follows the flag only for U.S. citizens. It applies to people, in some respects, who are here in the United States, more so to U.S. citizens than those that are not, and it applies to U.S. citizens that even may not be here. Legal rights of U.S. citizens, again, a Reader's Digest large print version, is entitled to an Article III type of court procedure under the Constitution. Reasonable communication to outsiders, legal counsel, a trial in the traditional sense, though not necessarily always with a jury, notification of the charges, bail in some cases to have a pretrial release right, so long as there is a security for their showing up for the hearing. Their physical presence at trial, again, although not always. You've read in the paper recently that a defendant has been excluded from the courtroom in his trial related to 9/11 because of disturbances in the courtroom. The right of confrontation, cross-examination, rational procedures, rules of evidence, and other protections of the Bill of Rights, at least in peacetime. However, again, back to the Supremes, they do not always say that's true in war. A very important case you'll hear about in the near future, Hamdan versus Rumsfeld, was decided by the D.C. Circuit last year. It says military tribunals are okay, and that persons in U.S. courts may not raise the Geneva Conventions or similar treaties in their defense in federal courts. The author of that opinion was a fellow named Roberts, who has since been promoted. He will not participate in the Hamdan decision, therefore, because he wrote the opinion at D.C. Circuit, but as the Chief Justice, now he may participate in the decision of who gets the privilege of writing the majority decision for the court. In war, rights are less. You all remember that Lincoln suspended habeas corpus, certainly without any constitutional authority to do so, and that the Supremes in Milliken, again rising out of the Civil War era, said that U.S. civilians are not to be tried by military commissions, at least where the courts are operating all right, and that, I think, is probably why we have a detention facility in Guantanamo and not in Tuscaloosa or Atlanta or Wichita. If they were within the continental United States, then ex parte Milligan would present some other issues in that regard. But there have been exceptions. This is a case you might want to read. Curran has to do with 4 Nazi saboteurs who were caught down in Florida, one of whom claimed to be a U.S. citizen. They were tried in secret by a military commission. They were convicted in secret. And they were executed in secret, but not before they were permitted to have an appeal to the U.S. Supreme Court in secret, which held briefing and oral argument in secret and issued its opinion in secret, not making it public until years later. but certainly evidence that sometimes in wartime even the criminal procedures and military tribunal procedures are not carried out the way I think we think about them in terms of conventional law. The war is going to last a long time. I think the simple proposition there is Al-Qaeda didn't train 10,000 people for 10 years so that 19 of them could fly 4 airplanes on one day. Mr. bin Laden gives a speech every once in a while to remind us of this. This is not something which will go away in the near future. It's something we have to plan for. The Patriot Act. What a great acronym. I don't know who thought this one up, but it's the USA Patriot Act, by the way, and all those words there at the top are what it really stands for. And it has to do principally with intercepting and obstructing terrorism. It was approved overwhelmingly in both the Senate and the House. It doesn't allow dabbling in whatever activity law enforcement chooses. It is limited to domestic terrorism, that is, that which violates a state or criminal law and is dangerous to human life. It certainly is not going to apply to any peaceful political advocacy, although if you get out on the edges, say with ELF or ALF, they might come close. The folks that take credit for blowing up buildings every once in a while and setting fires to labs, that might be there. What Patriot does, I put 3 different general categories on it. It equalizes FISA, that Foreign Intelligence Surveillance Act court, so that it can issue orders that are roughly equivalent to an Article III court in terms of search and seizure. It updates for technology. Voicemails now can be obtained by subpoena. They aren't considered a wiretap. Pen registers for emails. A pen register generally is something which traces, think of it like a number dialed on your phone. It doesn't pick up the content of the call, but it finds out where the call went. There's a trap and trace device that's also used. That's sort of the other way around. That figures out where the incoming calls are coming from. Again, doesn't get into content. Think of it in a paper world as looking at the outside of an envelope and being able to read both the address and the return address on it. Patriot does not authorize reading the content unless the email is already opened. It also codifies certain judicial precedents. Section 213 and the sneak and peek delays. This is a device where the government may obtain a warrant to go and look, actually, for instance, go into your house and conduct a search and not tell you they were there. If you watch The Sopranos, that's the microphone they put in Tony Soprano's lamp down in his basement, all right, to track the conversations he was having with his friends down there. When his daughter took the lamp to college, they cut off the warrant and didn't do it anymore because it was no longer within the scope of what they were asking for. But that's what a sneak and peek is. Obviously, there are reasons why you might not want to tell people that you are looking at some of their things because to do so would allow them an opportunity to destroy the evidence. Patriot Act oversight every 6 months. There are reviews done to Congress. And thus far, maybe Devin will correct me on this and have some other evidence on it, but thus far, I have not seen any public evidence of a single abuse under the Act.
Because it's all secret.
Feinstein and Senator Biden have issued public pleas repeatedly through the years. This one's from 2003. There are other ones from last year saying, please, pretty please, with sugar on top, somebody come to us and tell us they think that they've been abused under this statute, and thus far no one's found any, despite the fact that they give briefings to committees of Congress that are well known for disclosing everything up to and including troop movements in Iraq to the news media. No member of Congress has come forward with any disclosure of any abuse either. Most of Patriot is not new. The warrants that are issued by it are by a federal judge. They're based on probable cause. We talked about pen registers and trap and traces. Those aren't new. It did update them technologically a bit and allows them to be used for electronic methods of communication now. But they're old procedures. Sneak and peek goes back to '79 and was okayed by the court then. It's really the same stuff that's been used for years against organized crime, against child pornographers, against drug dealers. There are particular statutes that authorize all those procedures in those categories of crimes, too. That is why one of the reasons they were able to pass Patriot, such a massive statute, so quickly, is they were able to cut and paste a lot out of things that were already there and just apply them to domestic terrorism. The other examples, businesses have been always subject, including news media, including libraries, have always been subject to search warrants. My office is subject to a search warrant. If it contains evidence which is probative of a crime or instrumentality of a crime, it may be obtained by a search warrant. The word library is not in the statute. There's no exception for libraries, never has been. Critical evidence was obtained for libraries. In cases like the Zodiac Killer, who was an aficionado of a certain Scottish poet, I believe. So one of the detectives got the bright idea, let's go to the library and see who's checking out books by this poet. And that was one of the ways that they were led to the defendant who was eventually convicted in that case. Likewise with the Unabomber, one of the 9/11 perpetrators, I'll call them, they weren't convicted, so I guess you can't really call them convicts at this point. They were never determined guilty like Lee Harvey Oswald. But one of them actually used a library computer to confirm his flight arrangements. That's in the 9/11 Commission report. So libraries are used, and when they are used to commit a crime, there's really no reason why, like any other facility, their records shouldn't be available to law enforcement. Obviously, bank records are often used for transporting money, hardware, chemical companies for bomb materials, and a bookseller. A recent case involving a terrorist who was constructing a bomb, I think our shoe bomber was one, that looked at books regarding bomb detonators, and they were able to use that as evidence to prove his wrongdoing. Even Senator Biden says what's good enough for the mob should be good enough for terrorists, a reasonable analysis. For an alien, there is a lesser standard that is used. It is reasonable suspicion and not probable cause. But again, there's nothing unusual about a different standard being used towards aliens than towards U.S. citizens. It permits monitoring persons rather than devices. Again, if you watch The Sopranos, Tony tends to make a phone call and throw away his cell phone and reach into a box of cell phones and pick out another one, and that's what criminals do. They change cell phones all the time. So getting a search warrant for a particular phone number or a particular cell phone doesn't do you much good. Patriot broadens that and allows the warrant to be issued as to the person and any electronic device they are using. It allows those warrants to be nationwide. With a decreased reliance on grand jury subpoenas, I know all of you have read thoroughly the 9/11 Commission report, and you'll remember from doing that one of the problems was the separation between criminal justice enforcement and intelligence. They weren't allowed to talk to one another because things gathered in grand juries are secret by law. And therefore, if the grand jury was used for the investigation, that could not be shared with the intelligence agencies to be used either domestically or overseas to prevent terrorist acts. Urban legends, I mentioned libraries not in there. The 180-day notice is considered controversial. Devin will probably be upset about that. And one of the reasons you need that is because it takes a while to de-encrypt a computer. Even if you shut down the FBI and the NSA and the CIA and put them all to that task, you wouldn't need to have too many of these going before you'd tie everybody up, particularly with the foreign language and translation difficulties that go on. We talked about the pen register and the trap and trace, and again, the content is available to law enforcement under those provisions only if the email is already opened, just like an envelope. It's not an episode of Law and Order. If you analyze the fight against terrorism as a criminal procedure project, we are going to lose. And I think that is the conclusion that Congress reached with the Patriot Act. We cannot accord full due process criminal procedure rights to people who are fighting wars against us any more than we can do that on an open battlefield. That constitutional criminal procedure is not our precedent in war, and I think the current decision shows that. And that the Constitution does not apply at all times, everywhere, and again, nothing new about that. If it needs to be fixed, Congress can fix it. They're in the process of doing that right now. In another really close call, the Senate voted 96-3 just this past week to extend basically the same provisions another 4 years. Again, no documented cases of Patriot abuses, and the last set of Senate hearings revealed the same thing. Curative solutions are necessary. Thus far, we don't find much creative going on, either in Congress or, I might add, too, in the journals and the law schools, where we would expect creative solutions to be going on. I find most of the solutions being proposed to be very pedestrian, to hearken back to ancient times when the science and the enemy was nowhere near the same as it is now, but without really any effort to try to update those to what the realities of today are. Conventional law and military doctrine will probably not be enough to see us through this thing, and yet there's very little creative discussion going on in that regard. we have been creative. When Lincoln was approached with slavery, and read his first inaugural address, he admits quite candidly he's not permitted to release slaves. He's not permitted to do away with slavery under the Constitution. That was his political position. That was his sincere legal belief. But he figured out a way partway through the war to issue the Emancipation Proclamation. He did that using his war power. Read the first paragraph of the proclamation. That's what it's based on. And it's also why, under the proclamation, all slaves were not freed. The slaves that were in those parts of Virginia and Louisiana that were already under Union control were not freed by that proclamation. And in fact, later on, we needed the 13th Amendment to accomplish that under the Constitution. But the proclamation at the time, a very creative device, a great act of courage, and something which we, I think, come to expect of great lawyers like Mr. Lincoln. Another example, the Nuremberg trials. After World War II, we were presented with a very unique situation. The world had never faced what the Nazis had done. We needed a way to fix guilt on individuals, particularly among the leadership. And so we adopted a special procedure. No testimony was permitted. All the evidence was permitted only on paper. There was no cross-examination permitted. All the senior Nazi leadership was required to use one counsel. There were no appeals, and everybody announced that from the very beginning. That was going to be the final judgment. And they were tried for offenses that were not offenses at the time that they were committed under written international law. You remember Senator Taft got into a lot of trouble about pointing out the ex post facto problems involved in that. However, the entire Constitution does not apply everywhere to all people. It never has. Pacific Theater, General MacArthur had a different solution for the Japanese. He used those military tribunals you hear so much about. He didn't form a special court. He used the military tribunals and the Uniform Code of Military Justice, gave them all the rights of a court-martial, tried them that way with a right of appeal. And in fact, you can read Yamashita's case because some of them were appealed all the way to the Supreme Court. Again, not necessarily better or worse than Nuremberg, but a creative solution to a unique situation. Two great issues of our age. Will we treat terrorism as a crime, or will we treat it as an act of war? Compare the 93 World Trade Center bombing. Those people were tried in our criminal courts. We had public trials, in the course of which was disclosed the reason why the Trade Center did not fall. And that is that it was not vulnerable from the bottom. And there is testimony from the architect saying it is only vulnerable from the top. And there were days given of engineering testimony about why the Trade Center didn't fall. Guess who used that later on, and why we don't want to have all terrorist trials in public where they can be reported to the news media and third parties. You notice after 9/11, we treated that as an act of war, and those people, at least the people connected with that, obviously a lot of them died in the course of it, but those that have been connected to al-Qaeda have not been tried in open criminal trials, except for ones that was a U.S. citizen and those that were captured in the United States. The second great issue, security versus privacy. I can remember when flying was fun. I do a lot of it. And I can remember the first time they wanted to look inside my briefcase, and I was utterly appalled by that. The American Bar Association passed a resolution opposing it because there were client confidential materials in briefcases. Does anybody hesitate to open up their bags, take off their shoes, go through X-ray machines that see everything about you that can be seen? Now, we're quite willing to sacrifice that privacy for our security. And that is one of the issues, I think, that will continue to pester us throughout this debate. 2003 version, you are enslaved by your richest and the most influential among you, especially the Jews. This is on a little site that it goes off and on. Go and look at it. Sometimes it's called Jihad Online. They publish everything that they're saying. They aren't secretive about it. They're very open about all of their theories and even about what they're going to do. And may our mothers become childless if we leave any of you alive. There are lots of bad people out there who want to kill you and me and our children. And we need ways to protect ourselves from them. Thank you.
Thank you, Mr. Allen, and thank you, excuse me, also to my friends in the Federalist Society for inviting me. I also applaud the audience. It wasn't all that long ago that I was in law school, and frankly, you couldn't get me out of bed before noon on a Saturday without a crowbar. And so obviously this is a group of law students who are more diligent than I. I obviously am going to take a different tact in this discussion because I am appalled not only by the Patriot Act, but also the abuses that we've heard about recently in terms of Al Ghraib and the beating of terrorists or alleged terrorists, as well as the what I perceive to be, if not unconstitutionally, certainly anti-American holding of terrorists or alleged terrorists, again, down in Cuba. I've titled my presentation as America, Land of the Free or Land of the Afraid. We've just heard from the Land of the Afraid that we need to be afraid of all these terrible people who are out there that want to kill us and our children. The real question is, how real is that fear? And the second question is it so real that we're willing to give up fundamental issues, fundamental rights that go to the core of what it means to be an American? We are subject to a vicious attack. A group of radicals bent on America's destruction strikes from the air while we sleep. Radicals from an ethnic group pleading allegiance to a system of beliefs that we don't understand or don't appreciate launches a surprise attack. The response, well, exactly what you'd expect it to be. America springs into action. A war is declared by the president. Presidential orders are issued. They're necessary for national security. Laws are rushed through the Congress to put increased authority and powers in the executive branch to fight these instruments of terror. You might note that the Patriot Act was passed. The first version came out exactly 1 month after the September 11th attacks. It was signed on October 26th. So much for debate. Intelligence services and the FBI spring into action and start investigating alleged terrorists and terrorist organizations. Civil rights are restricted. The year 1941. This is what occurred after the Japanese attacked America. Some of the worst racism, some of the worst racial rhetoric you will ever hear came out after December 7th, 1941. Laws were passed and powers and authorities were given to the president to attack and to defend against this scourge. The scourge? American citizens of Japanese ancestry. The result of these powers, the result of this little debate, the result of Congress ceding congressional authority to the executive branch, concentration camps for all individuals of Japanese ancestry. Now, I've actually been to one of these concentration camps located in Utah, where we sent law-abiding American citizens of Japanese ancestry, and they truly were concentration camps. Dozens, if not hundreds of people jammed into small dormitories out in the very bleakest, hottest, and some of the worst territory in all of America. So it goes to the Supreme Court, Article 3 Court, our final, shall I say, speed bump before civil rights are run over. And we have the Korematsu case. If you haven't read it, you should read it. Korematsu was in prison. He was an individual, an American citizen, a law-abiding American citizen, no prior convictions, no prior arrests. He was a patriotic American citizen. He was imprisoned in one of these concentration camps. Actually, he was prosecuted for not voluntarily showing up to be put into one of these concentration camps. And the Supreme Court, in an opinion that many feel is the worst travesty of justice since the Dred Scott case, rules that the executive branch, the military tribunals that Mr. Allen speaks of, have the authority to take American citizens and put them in concentration camps. And read the language. Why? Because it'll resonate, because we're hearing the same language today as we fight the so-called war on terrorism. From the Supreme Court, Korematsu was in prison because we are at war with the Japanese Empire. Well, we have thousands of individuals locked up, including American citizens, down in Cuba because we are at war with the Islamic Empire, or the radical Islamic Empire, if you want to give the folks that support the Patriot Act their due. Because the properly constituted military authorities feared an invasion of our West Coast. Well, We've given new power to the executive branch, new powers to the FBI, new powers to intelligence organizations because we fear of an attack from folks that support radical Islam. They decided that the military urgency demanded that all citizens of Japanese ancestry be segregated from the West Coast temporarily. Temporarily. Well, what do we read in the Patriot Act? It's not so bad. It's temporary. It's not so bad. It has a sunset. Well, not anymore. February 17th. Sunset's basically gone. Actually, the final vote's going to be in March, but the sunset's going to be gone. Oh, we'll resunset it for 4 more years. Guess what? We've heard Mr. Allen a moment ago state this is going to take 20 to 40 years. It's worse in many ways than Korematsu because we've given this rights, these new powers to the executive branch, which I'll talk more about in a moment, under the theory, the oversight is they're going to go away someday. Well, now we have a proponent, and I credit Mr. Allen for being candid with the group. These aren't going away unless real Americans, true Americans, Americans that believe in the Constitution stand up and say, it is not appropriate, even in a situation where national security is at risk, for us to trample the constitutional rights we've been given in the sake of some safety. And what I would suggest to you is not real safety. September 11th, 2001. Another day that will live in infamy. I believe it will live on in infamy for 2 reasons. One, because the terrible toll that was placed upon the individuals that died in that or were injured in that horrific attack because of what it did to the American psyche. But I believe also it will be a day of infamy because it will be the day that when we look back in 20 to 30 to 40 years ago, as we have done now with Korematsu, recognize that we gave up liberty in the name of false security. I believe that in 20, 30, 40 years from now, September 11th, 2001 will live as a day of infamy because it is really one of the watershed events that led to the erosion of our civil rights. 1 month later to the day, Congress reported out, it actually did not get signed until October 26th, passed the so-called Patriot Act. Now, the Patriot Act, as Mr. Allen has properly pointed out, has many different elements. It touches upon many different areas. I want to focus on a couple of them. Section 215, which creates or expands the powers of these so-called NSL or national security letters. I'd also like to discuss in a little more detail some of the erosion of the search warrant protections that we've historically enjoyed over the years. Now, I've got to pick up on something Mr. Allen said. Nothing new under the sun. We've had these powers. Well, just because we've been doing something poorly for 20 or 30 years doesn't make it right. So I guess my attack is not only on the Patriot attack, isn't that an interesting slip? The Patriot attack. The Patriot attack on our civil rights, but also on the enabling legislation before it that created the FISA legislation, the Foreign Intelligence Surveillance Act, which created these secret courts that we've talked about. So when I talk about the Patriot Act, it's not just the Patriot Act, but rather the full gamut of power that has been expanded by the Patriot Act. But let's start off with the Patriot Act and a couple of points on it. Get this. Based on a largely unexamined certification by an FBI agent that Devin Schindler gave a speech in which he supported terrorism, I was a little hesitant when the invitation came in for fear that Mr. Allen was going to call his favorite FBI agent. I know you wouldn't do that, John, but I have to pick on you anyways. That I was out there expounding the rights of terrorists based on an unexamined certification by an FBI agent presented to a secret court. Secret, ooh, scary, star chamber. The FBI can now read my emails by delivering this letter to my service provider. They can deliver one of these letters to my cable companies to see what movies I watch. Now, I'm not saying I watch pornographic movies, but I don't want the FBI to know what I see. They can listen to my voicemails. Well, isn't that like telephone? It's on a telephone. You talk over a telephone. No, it's not like telephones at all. They don't have to jump through the hoops to tap my phone anymore. They can listen to my voicemails based on these NSL letters. They can find out who I called and when I called them. That's the pen registers and the pen traces that Mr. Allen mentioned. They can get medical records. We may debate this a little bit. I believe they can. They can subpoena my credit card. I call subpoena. It's an NSL letter. Credit card information and bank account identifying information. Basically, all of my transactional information that's held by third parties. Now, to be a human being, to be an American citizen, you do a lot of transactions. You watch movies, you check out books. There's two kinds of transactions that you do. There's the business transactions that you do, credit cards, banking and things like that, and what I call the personal transactions that I do. Check out books at the library and things of that nature. That distinction is important because notwithstanding Mr. Allen's spirited and well-spoke defense of the Patriot attack, or the Unpatriotic Act, if you'll accept my particular version, these national security letters, they have made a change in what used to be. Now, what they used to have is still not very good, but they have expanded the powers of the FBI and government agencies in issuing these national security letters. An application is made to a foreign intelligence surveillance court, the secret courts that we've heard about. They certify. All you have to do, if you're an FBI agent now, is to give the magic language. My 12-year-old son, if he was an FBI agent, could get one of these, simply by uttering the magic words that the information I seek is relevant to an investigation dealing with national security. This is a new lower standard. Now, the old standard wasn't very good, but that's no defense to make it even worse. The old standard was you had to make a showing to this court of articulable, which I can't articulate, articulable facts showing that the target is a foreign agent. That was the old standard. The Patriot Act makes this a new standard. I hereby certify to you that we're have an investigation going on and Mr. Schindler's relevant. Boom, hey, go talk to his service providers. Go see what books he checks out. No problem. How is a court, any court, much less the secret court, going to give reasonable oversight? How can they challenge, because it's a secret non-adversarial proceeding, whether or not that certification is realistic or true? Well, they can't. This is not real oversight. It wasn't before, even under the old standard, and now we've even eroded it even further. And they've expanded. Here's the other big expansion we have in the Patriot Act. In the old days, under the old police state that we lived in, if you'll accept my demagoguery, it was largely limited to business records, my credit card information, my banking information, things of that nature. Now, under the new Patriot Act, it's all tangible evidence, tangible items. That's where we get the library cards. That's where we get the information about movies we've seen. So not only does the new act lower the standard necessary for the government to send out these letters and force third parties to give this information, they've also expanded the information you can get. Hence, the visits to the librarians that if you get on the librarian's website, they're screaming about. Now, Mr. Allen talks about there are no documented abuses. Well, Mr. Allen's definition of abuse is far different from mine. I don't want the federal government to know what books I read. That's a First Amendment right I have, and it's none of their business, much less on a standard that it's we need to know from a relevancy point. I suppose if you go through a true proceeding and you show probable cause, which of course the Fourth Amendment reflects, that's a right I'm willing to give away. I'm not willing to give away as an American my ability, the right I have to check out library books and read what I want to read based on a relevancy standard. Well, I'll get a chance to defend myself, right? When I discover the government's looked at my books and all that, I can sue the government for trampling on my rights. No. Why? Because it's secret. The proceeding's secret, and get this. If my librarian calls me and says, hey, the FBI was just here and they just found out that you've checked out 40 books on Muslim law and the Quran, they get prosecuted. Where's the Constitution? I could go on, but because of our limited time, I have a whole speech I get on my soapbox right about now, and you can assume I just did it. All right. That's the national security letters. It's relevant to an investigation, so we want to figure out what Schindler's reading. Why is it relevant? Because he gave a speech to a law school where he opposed the Patriot Act. That's the standard. You know, I find it interesting. People that support the Patriot Act, generally I have found, and I won't speak for Mr. Allen, who again is a very intelligent man and well-spoke, but people that support the Patriot Act, I've generally found are people that have not had dealings with the criminal law enforcement society, like your teacher. Anybody who's dealt with the FBI, anybody who's dealt with local police, anybody who has dealt largely on an adversarial basis understands that the trust me concept doesn't work. Just like any other profession, there are many very good police officers that will protect your constitutional rights and believe in the Constitution. But there's a good percentage, 20, 30%, that just want to get the bad guy and forget whether they're Americans or not. So the trust me, no abuse doesn't work because there's good people and bad people, just like there's good lawyers and bad lawyers. The other point I want to touch upon is the change that we now have in the issuance of search warrants. Again, we have our secret courts issuing these search warrants, still have the probable cause standard, which I suppose is something, but now we can have roving warrants that include secret seizures of your business records and the sneak and peek. Gotta love the sneak and peek. Doesn't it speak for itself? We don't like sneaky people in America. We don't like peeking. It sounds voyeuristic. But now we have the sneak and peek warrant, which we can look in your undie drawer, right, and not even tell you we're doing it. Oh, now, wait a minute, Mr. Allen stands up. All right, Sim, you'll stand up, Mr. Allen, and say, we eventually have to tell you, because there is the 90 and 180-day rule that after they do it, 180 days later, they have to tell you. Guess what? They can get that extended based on, quote-unquote, national security reasons. Gee, we couldn't get around. I'm sorry, because this was encrypted. We couldn't get around. We want another 180 days to tell this person. The secret court says fine, boom. War goes on for 20, 40 years. I'm not going to find out. Let's be realistic. The government, because it controls all of the evidence in these cases, is going to get what it wants. Because they're non-adversarial and because they're secret. If the government wants to not let you know that they've peeked into your undie drawer, you're never going to find out about it. Or if you are going to find out about it, it's going to be 10 years later or 5 years later when there's some declaration of victory in this war on terror. And you no longer need to show that foreign intelligence is the sole reason that you want to do sneak and peek. That was the old standard. Now, again, it's the relevancy standard to investigation. They've lowered the standard yet again. God help you if you're a Muslim-based charitable organization. No abuses? I got one for you. 12 different Muslim charitable organizations have had their assets frozen, their documents, in some cases, seized and others examined. That's the death penalty. This is before any adversarial proceeding. Boom, they come in, they freeze your assets, you're done. Now, they still exist, but with frozen assets. In my world, that's an abuse. And the problem is with a lot of these Muslim charities, they've had their assets frozen, they've had their documents seized, and the government won't give them back because of national security reasons. Well, how do you prove your innocence? What's the outcome of this? And again, I disagree with Mr. Allen. In 2004, I read a report. The source is opengovernment.com, so take the source for what it's worth. But they claim, at least, that 1,754 search warrants have been approved by the secret court in 2004. Guess how many have been rejected? 0. Now, look, I'm a pretty good lawyer, I'd like to think. John is a pretty good lawyer. I know he is. I've never gone 1,754 to 0 ever. If so, I'd be in the Lawyer Hall of Fame, okay? How much oversight is there really if these figures are correct? And I cannot, because all of this is secret, I'm not going to say that the figures are necessarily correct. But certainly, the government's got a pretty good batting average on these, as you'd expect. 545 library visits in 2003. The source of that is the Library Advocacy website. A dozen nonprofits with seized assets. A couple sources on that. There's a case pending down in Ann Arbor where one of these, where a Muslim-based organization is fighting the Patriot Act. Pacifist groups targeted. Women in Black, a pacifist group whose mission is to bring peace to the world in Colorado, was investigated under the Patriot Act because it has Muslim constituency. 100 campus Muslim groups have been investigated. Now, imagine for a moment that the government decided that Christianity, because it called for a second coming and an Armageddon, was a terrorist organization. And the government launched an investigation of Christian college-based groups. The outcry would be unbelievable. But because we're dealing with a minority population in our society, a population who has beliefs that many of us do not understand, there's hardly any outcry at all. Are we Americans? Is it okay to target people because of their religious beliefs? What happened to the First Amendment, for gosh sakes? We've got attorneys being prosecuted. U.S. v. Lynn Stewart. She represented a well-known figure, a so-called terrorist. They thought she was sending messages back between her client and a terrorist organization. She was prosecuted. The judge threw the charges out and said, you're attacking the very attorney-client privilege. 300 local governments in 27 states have passed anti-Patriot Act resolutions. Doesn't that speak for itself in many ways as to the constitutionality and validity of this act? Well, who cares? We've got a little more safety. Well, I'll tell you two people who care. One person that cares, one group that cares, the people that wrote the darn Constitution. We can argue this, but the point is that the First Amendment says Congress shall make no law respecting an establishment religion or prohibiting the free exercise thereof. How free, if you're a Muslim, a peaceful Muslim, to exercise your religion if your college organization has been investigated, if the charities you donate to for purposes of peace and for Muslim support have had their assets seized. Now, in a moment, Mr. Allen's going to stand up and say the word Muslim doesn't appear, that this is not a Muslim-based initiative. This has nothing to do with your religious beliefs. Well, disparate impact. Clearly, without any debate, there has been a disparate impact as a result of the Patriot Act on Muslim-based organizations. I don't know of a single Christian-based organization, and I could be corrected on this, who's had its assets seized because of under the Patriot Act. What happened to the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures? Excuse me. Well, I personally think that my bank records are personal. Well, the government doesn't believe that, and in the case U.S. v. Miller, unfortunately, the Supreme Court agreed. How safe am I know the government, upon a showing of probable cause to a secret court that I'm not even a foreign agent, can come in and sneak and peek around my house? Good heavens, I'm going to go home and tell my wife to clean out everything. There's a whole issue of separation of powers here. We don't have time for it. I would love to come and talk about the separation of powers issues because I think they're complicated, but we do continue to see the emasculation of Congress, if you'll accept my sexist term, at the expense of our private rights to the benefit of the executive branch. Who cares? Well, the founders care. One of my favorite quotes, I've already told John it was coming. Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. Folks, it's on bumper stickers. It's trite, but it's true. Freedom is not free. And so fundamentally the question becomes, are we willing to sacrifice what some call technicalities? I call them your fundamental civil rights, your fundamental right to not have the effect of warrantless searches, the fundamental right to protect yourself in both your daily transactions and your business transactions for this alleged, non-proven additional security. Will people die if we protect our civil rights? Absolutely. But people have been dying for 225 years or more for our civil rights. And I, for one, am willing to give up a little personal security to know that I don't have the government secretly sneaking around looking at me because of a particular religious belief or a particular organization I belong to. Mr. Allen.
Gentlemen, I think in the interest of time, maybe about 10 minutes for rebuttal and discussion.
It won't even take that long. In fact, I won't even stand up, all right? A couple things I think we need to emphasize, not only in the debate about Patriot, but about the age we live in. Patriot, however, is a good example. Let's first of all be clear about one thing, not only about Devin in particular, but about folks in general at debates and discussions like this. This is a really great thing. This is what we are fighting to make sure is maintained. And you may be a patriot and oppose Patriot. They are not inconsistent with one another. These issues deserve to be debated, and I commend you on inviting us here today for that. However, that being said, a couple of points do deserve response. I realize that 5 years is not very long to debate some congressional statutes. In fact, Congress sometimes takes decades and still doesn't pass anything at all. But Patriot has now been debated 5 years. It's going to be renewed at very much the same margin it was originally enacted 5 years ago. I think because after all the debate, after all the examination, after all the oversight hearings, after all the news leaks, and after all the polls, it's been pretty well established that not only is it helping, but it's very well supported by the American people, and properly so. I don't know how to tell you not to trust governmental authority, because I think to some extent we have to do that to a certain degree. I was accused of not having experience with law enforcement, but I'll tell you that although I've never had the honor of serving as a prosecutor, I have served as a defense lawyer. As a JAG officer, I served as both a defense lawyer and a prosecutor, and my father was a cop. So I've been around law enforcement, and I can tell you that most law enforcement, like most soldiers, are good and upright people. In fact, they're the sort of folks that, generally speaking, on a day-to-day basis, care a lot more that their official actions comply with the law than do a lot of folks that either take a lunch pail to work or run a business or a law school or a law office, for that matter. They think about it all the time. They're very conscious about it because both police officers and soldiers know that their actions are going to be reviewed in detail after the fact, and if they haven't done them properly, they will suffer consequences for that. The solution is not to trust folks. The solution is to verify. Trust and verify. That's what Mr. Reagan used to say about our foreign policy. It's really a pretty good approach, I think, to many of these items. And when you find abuses at a place like Al Gharaib, it doesn't mean you close it down. It means you take the people who broke the rules and you charge them under the Uniform Code of Military Justice. You try them, and if they're found guilty, you punish them. That serves not only to achieve some equity in regard to those individual acts, but it also serves as important deterrence to others and reinforcing that the obedience of those rules is a very high priority to us. All of the prosecutions, I don't think, are what Devin makes them out to be. Lynn Stewart, for instance, although most of the charges were dismissed, read the facts of the case. She was in direct contact with al-Qaeda on behalf of her client and passing information back to them. In fact, the al-Qaeda manual, which used to be posted on the internet back then, told all of their operatives, if you're ever arrested in the United States, ask for your lawyer immediately, and here's the list. And they had people on the list to use, much like Tony Soprano probably does for his crew. So they know that was a protection that could be offered. And one of the tensions we're going to have to battle in the coming years as lawyers, and you as lawyers, is how we are going to protect the confidentiality of the privilege and the attorney-client relationship within the scope of that crime-fraud exception that's already there, and not damage the profession, not damage the compliance that privileged conversations bring, and still achieve security and law enforcement and success against the war against terror. This is not about concentration camps. I just want to emphasize that. However, it is worthy to be on the alert for that because it does involve an enemy who, at least based on what we know so far, does have among its ranks a commonality of ethnicity and religion. And that does present a dangerous situation. Devin's correct in that regard. It bears great vigilance on our part to be sure that those matters of identification are not taken and generalized to abuse others. That is something which is in our hands, and probably more in your hands than in Devin and mine in the coming years, to remain vigilant about that and to make sure that those abuses do not occur.